Before we get to questions, let us listen to the oral arguments of Jeremy Feigenbaum on behalf of the government respondents.
Chief Justice, and may it please the Court. This Court should deny the emergency application because this injunction was properly designed to ensure that the states would get relief for our own Article III injuries, as we suffer significant pocketbook and sovereign harms from implementation of this executive order, including from the application of this EO to the 6,000 babies born to New Jersey parents out of state every year.
It shouldn't surprise you that the attorney for the clients who are getting their way thinks the injunction was properly designed. I will show during the questioning that this is based both on the elevation of precedent above the law and the low information decision of judges.
The U.S. prefers alternative approaches for granting that relief, alternatives it never raised in the district court below. But its approach would require citizenship to vary based on the state in which you're born, or even turn on or off when someone crosses state lines, raising serious and unanswered administrability questions, not just for the federal government, but also for the states.
This statement about 6,000 babies born out of state confused me at first, along with state-based citizenship. That, too, will make more sense as we go through the questioning.
And it would offend the text and history of the Citizenship Clause itself. Since the 14th Amendment, our country has never allowed American citizenship to vary based on the state in which someone resides, because the post-Civil War nation wrote into our Constitution that citizens of the United States and of the states would be one and the same without variation across state lines.
The statement about citizenship being uniform among the states is true, but not the way New Jersey and other respondents think it is.
The U.S. has claimed that Article III establishes a bright-line rule barring such injunctions no matter the circumstance, even where the states do need it to meet their own harms, finds no support in this Court's cases or in the history of equity. Its argument that a single district court cannot decide birthright citizenship or that we need more percolation on that question for the nation overlooks that this Court already settled this exact constitutional question 127 years ago, and that this EO is contrary to over a century of executive practice.
While the Constitution doesn't mention injunction, Article 3 does state, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority." The question is, how far does that case extend? The arguments on both sides have merit, at least in certain circumstances. I'll delve deeper into this as we go through the episode.
Finally, the U.S.'s objection that nationwide PIs have simply become too common in the last few months, a complaint about other injunctions sought by other parties, cannot undermine the extraordinary bases for this one. The states, who regularly come before this Court as plaintiff and defendant alike, agree that nationwide relief can be reserved for narrow circumstances, but it was needed here. I welcome this Court's questions.
To me, it seems the problems of forum shopping and overly broad injunctions create a positive feedback loop. Attorneys search for judges who will be sympathetic to them, who then issue nationwide injunctions, thus encouraging more forum shopping.